Hey, good afternoon. Good afternoon, everyone. Welcome to a new season of our leadership series, season 6, episode 1. So we're very happy to have you. Welcome back, Michael Bender. How are you today, Michael?
I'm great. Thanks, Craig. Good to be back.
Good. And welcome to Alan Schwartzside. Alan is pinch hitting for Jeff Rembom, who's on a cruise. So we're very jealous of him. But Alan, welcome back. I guess you're a regular pinch hitter, which is good. But we don't all know you. So will you tell us a little bit about yourself, if you don't mind?
Sure. So I've been practicing in community association law for, 14, 15 years now. Did 2 miserable years of mortgage foreclosure before then, and then had the pleasure of joining a previous iteration of KBR before Jeff Rembom joined the firm. And been back for about 2 years, growing and working in the Orlando/Winter Springs office, and just happy to be here today with you all. Thanks for having me.
Great. Great, Alan. Thank you. Thanks so much. I want to remind everybody that Michael and Alan are not here to give you specific advice for your association, but instead provide guidance on the topics we're going to tackle today. You can, as Marinez said, continue to chat in your questions. We'll try and work those into the discussion. We're going to lightly use polling, mostly just to find out who's in our audience today. So, Ness, can you just post the first poll question so we can see what type of communities that our audience lives in, and then so we can get that data. That'll be good, guys. In the past, this is a legal update to some extent. In the past, we've done legal updates, what the new legislation was, and it was substantial. So the idea today is to really revisit those changes to the legislation and look at what, some of these had deadlines of July 1st, some of them had deadlines of October 1, some running through the end of the year, and some even into next year. So we really wanted to check in with our communities that are listening in today to see, okay, what should have been done, what's upcoming that you have to get done, some other kind of checklist of items you should look at year end. So that's our intent today for those that have checked into the webinar. Marinez, can you pull up the agenda? Because I want to go through the agenda so that we're kind of all on the same page here. So education requirements for all board members and official records for all associations. We're going to tackle those together. So Michael's going to address the education requirements. Alan's going to address the official records for all associations. Then we're going to get into some very specific condo deadlines, HOA deadlines. We're going to revisit the milestone inspections and CSRS deadlines because those are approaching rapidly. We're going to talk a little bit about the Corporate and Transparency Act, which applies to all associations. A couple of other deadlines. Michael's going to give us an update on what might be on the horizon for our associations next year. And then if we have time, and we may not, but if we have time, we'll answer some questions. So with that being said, can you post the results, Marinez, of our audience? There are a couple of cooperatives, which is great. So about half and half, about normal, a few more condos than HOAs. So it's a good balance because our agenda is well balanced between condos and HOAs. So let's get started, Michael. Lots of stuff on education and certification as it comes to board members. So can you take us through what the legislation says and what has to be done now?
Yes, I'd be happy to. Hello, everybody. Craig, Alan, it's good to be here. Aaron is, again, thanks to Castle for putting this together.
Of course.
And we will start with education. So as Craig mentioned, there were a lot of legislative changes this year. Both Alan and I will be teaching the legal update over the next few weeks, this week, next week, week after, which will really hit heavy on all those legislative changes. So appreciate that Castle's doing this highlight reel because these are important things for you to know. With education, I'm going to differentiate, I'm going to point out condominium and HOA. And for our couple of co-op listeners, your education requirements have not changed. They did not address 719 when it comes to the certification requirements. But with regard to the condominium board members, prior to the change in the law, you could get certified one of two ways. You could sign an affidavit, a written certification that you've read your governing documents, you will uphold them, meet your fiduciary duty, or you could attend a division provider approved education class. Well, in the condominium setting, that or is now taken out. It's an and. You are now required to attend a division-approved provider new board member education certification class and fill out that written certification that you've read your documents. You will uphold them. You will meet your fiduciary duty. It is now an and. Okay. You must be certified. You must take this division-approved course within 90 days of being elected or appointed to the board. You can take it up to a year before you're elected or appointed. So, for example, if you know your election's in January and you are running for the board and you expect to get onto the board and you took that division-approved class today, your certificate could be turned in on the date of the annual meeting after you get elected, and it would qualify because you're less than a year from the election date. So 1 year prior to the date of the election or appointment, or within 90 days after election or appointment, is when you need to have that certification. That certificate is valid for 7 years. You do not need to resubmit a new certificate for 7 years, so long as your service on that board is uninterrupted. If your service is interrupted for any reason, you step off voluntarily or you're not elected and then you get back on during the next term or the following year, you must redo the certification program. With regard to the certification course requirements, this is all condominium. HOA I'll do next. This is all condominium. Okay? The board member certification course by statute must be at least 4 hours long. That is what they've dictated. They have provided us the several different subject matters and added a 4-hour requirement for them. So as a firm, KBR, we have already been approved. We have been teaching them. And as you might imagine, they are team taught usually. And they are taught in 2-hour blocks or alternating. It's a lot, and it's a lot to ask of volunteer board members and property managers who want to take that board class to sit for 4 hours. We did reach out to the division. We did ask, is there a way to break this up? In fact, I submitted 4 part A, part B, part C, part D, asked them to approve 4 1-hour classes. That has not come through yet, but we have been told that you can submit 2-hour classes and teach it in 2 separate 2-hour blocks. The key there, though, is if that does ultimately get approved, and for example, if it does, we will then offer it. Complete hypothetical, I'd say the first and second Tuesday of the month, we're going to teach the condo board cert. You need to, the first part A and B will be on the first Tuesday, part C and D the second Tuesday. You must attend both in order to get your certification. You can't attend one and not the other. And you need to attend the entire class, not just check in. You know, we keep track of that, and if you are checking in and then checking out, you will not get your certification. The state is asking us to monitor that. They will check us. So do know that you should be attending the entire time. Craig, did you have something? No.
No, I didn't. I just think it's interesting, the requirement on you to make sure that people are staying through the registration process. I think that's good. Frankly, if you're going to take the education.
There's always been a quote audit requirement. Like that's why we've always asked, is anyone who attends our classes knows that we ask that you sign in at the beginning and then you fill out your surveys at the end. And so we have both that confirms that you've been in the class. And that virtually now, obviously, as many of you may know better than me, they timestamp you when you're in, when you're out. So, you know, you should be, and by the way, if you're there for the education, you should be there for the education. But in the condo setting, it's a 4-hour class. There's several topics that are going to be taught, including milestone inspections and structural integrity reserve studies. Whether or not that applies to you, that's part of the teaching. Elections, record keeping, financial literacy, transparency, levying of fines, notice of meeting requirements. All of that gets gone over, okay? If you are a current, and this took effect July 1st, 2024. So if you are elected or appointed after July 1st, within 90 days of being elected or appointed, you need to have taken this class. Okay, and I guess August, September, October, you're past your 90 days. So if not past. So the key here is if you were already a seated director on July 1st, 2024 in the condominium, and so you'd previously been certified under what we'll call the old education requirement, you must take this 4-hour class. You are given until June 30th, 2025. You're given 1 year. So you're not hooked to that 90-day period, but within 1 year, you need to have taken it. And I would encourage you, because as I said, we're giving them all the time, you take it sooner than later. Because
Michael, I think,
it's
sorry.
good information. Go ahead, Craig.
That's a good distinction. So we have had a couple of questions. If you were a board member prior to July, you have to still take the 4 hours training. You have to have your certificate, but you get a year to take it, not 90 days.
Correct. By June 30th, 2025, if you were seated director on June 24th, excuse me, on July 1st, 2024, you already seated, had already done the, and if you were seated, presumably you had done your certification, and that was on file
Right.
with the association, you're okay. But if by June 30th, 2025, you have not gotten the new certificate, and the division did create these certificates now, it's not provider approved certificates. The state has said, here's a certificate you are required to use for the new classes. So you're going to need to have that in place, okay? So that is your new board member education certification for the condominium director. Condominium directors also have a continuing education requirement, 1 hour a year on the new legislation. Now, I encourage you to take a lot of education. We offer classes in many different subject matters, as you've seen, I hope, if you've been at our classes or website or get our emails. But you are mandated to have an education certificate. So I said what we separate them is you have a new board member certification certificate, and then a 1 hour board member continuing education certificate. And they need to be on file with the association, and they are good for 7 years so long as you remain on the board uninterrupted. Okay? That is your condominium world.
Can I make a comment, Michael, just to remind everybody to emphasize the 1 hour every year. Normally our boards take a legal update. That is the normal course for board members because that's the most relevant. But to your point, there's lots of education out there and available, especially from you guys. You guys are all over this.
Right.
So.
Well, and to clarify, the requirement in the condominium setting is a 1 hour legal.
Okay.
Now, what we're doing, because the 2025 legal update, which goes over all the changes from 2024 that I'm teaching tomorrow, Alan's teaching in Orlando in early November, we're teaching in Tampa, all in Bradenton. That is a 2 hour plus, which goes over all the changes that impact condo, HOA, a couple of co-op, and just manager impact. So the board member class, we're going to submit a 1 hour class that just is condo related. So that condo board members don't have to sit through the hour on HOA or on other things. So that's so, but yes, it would all be legal on the legal changes. Okay. Secondly, I saw some questions too. If you do not have your certificate on file, okay, if you have not met the certification requirement by the deadline dates that I've discussed, then your seat is considered abandoned by you temporarily. It's a temporary abandonment. The board can fill your vacancy until you come into compliance. This is one of those where it's not you don't have to be reappointed. You can get back on the board once you come into compliance with the certification requirement. So if you're a board member now, if you were as of July 1st and you don't take the new 4-year course and now it's July 1st of next year, you're off the board until you take the 4 hour class, then you get your seat back. Okay. So if you get elected today and 90 days goes by and you don't do this board member 4 hour board class, you're off the board until you take the class. Okay. And that's going to be the same in the HOA. Pardon?
If you're suspended that way, the question becomes, do I need to take a new class if I had taken it before? Obviously, you wouldn't be suspended for that reason, but I wanted to point out for other suspensions that might exist, do you have to take a new class if you've only been suspended and not completely pulled off the board? Because the way that you phrased it was you're off the board. But in reality, this one is a suspension, and there are several other things that will cause a director to be suspended from service. So
I'm talking specifically the education requirement. You are temporarily off the board.
I understand. What I'm saying is, if you're suspended for another reason, is your opinion that, that suspension, you don't have to take the class again, or you do have to take a new class after your suspension is lifted for some other reason?
Oh, because now you're no longer off the board. You're no longer on the board uninterrupted.
I've had that question many times, which is why I asked.
Yes. I mean, the way the statute, well, what have you answered?
I've answered that it is a suspension, not a removal. and therefore the service was continuous.
Okay. I mean,
That's good.
I think that's a fair analysis of the point.
Yeah.
But you know, but in any event, so that's the situation with condominiums, and there's a lot of overlap in HOA as far as timeframes and temporarily being suspended if you don't comply. But that's where the similarities end, because Tallahassee did not do us the favor of making these education requirements uniform. So for the HOA board member, it is, again, as of July 1st, 2024, you are required to take a new board member education class. That certificate, that affidavit that you've read your documents no longer applies at all in the HOA world. So the condo, you're doing both. So affidavit and class. HOA, you're just doing the class. The affidavit is even referenced as relevant any longer. So the class doesn't have a time frame. It's not a 4 hour. It's you know, our class has been approved for up to 4 hours because there's a lot of material, but it can be taught in 2, it can be taught in 3. It's just important that you're taking the class. And that class, again, needs to be taken within 90 days of election or appointment, or you could take it 1 year prior. And it's valid for up to 4 years.
Not 7.
Yeah, not up to 4 years. So the implication there is if you are taking the class 4 years later, you will then need to take a new board member certification to have it for another 4 years.
Okay.
What is unclear is if you are a director on July 1st, where you have taken the old certification, there is no time frame like in the condo world that you have to take the new one by a dead date certain. I think it's reasonable to say that you have to have taken it though within 4 years.
4 years.
If you got certified, if you were certified under the old law, you know, like if you were certified prior to July 1st, say more than 4 years ago, I'd say take the new board cert. But you know, again, they don't clearly define it. I think the best bet, because there are a lot of new laws, as soon as you possibly can, board members, whether you're an older board member, whether you're a new board member, take the class. It's good for 4 years. Okay. That is the board certification. Your continuing education requirement for the HOA is more substantial. Condo, you remember 1 hour on legal changes. HOA, if you are 2,500 parcels, if you're fewer than 2,500 parcels, you have 4 hours of continuing education. It doesn't say in what. I would recommend get the legal, but it's 4 hours of continuing education on HOA related legal matters. If you are 2,500 parcels or more, you're 8 hours a year. Okay. And the association is required to retain these certificates for 5 years. And by the way, in both condo and HOA, if you fail to retain the certificate, it's not going to impact the validity of any actions the board has taken, which I love that they do that. They give you these mandates and then say, but if you don't do it, don't worry about it. So, I mean, that is a general overview. That is a general overview, guys. You know, if you have any specific questions, definitely get with your counsel. Make sure you're doing this right.
That's excellent. I think, Michael, you made the point. Listen, this isn't a checklist item for board members. Really, I mean, if you're looking to do it because it's on the checklist, there's good education out there to, you know, make yourself the best board member you can. It's a bit of a soapbox, but I would say take the courses because they're good, not because you have to, even though you have to. And I will say, we're going to talk about official records later, and these certificates are part of the official records of the association and have to be posted on the website. So there's some self-policing of this as well. But Michael, that's a great summary. Thank you very much. Alan, let's move on to official records and a couple of things. One, I wanted you to review the law. Marinez, we do have a checklist of official records for an association that we've pulled with Michael and Alan's assistance out of the statute. So if you could show that, so as we're walking, Alan's walking through the stuff, everybody can see what the official records are. But Alan, let's start with the current law, and then I want you to get into official record requests and all the changes relative to official record requests, if you can.
Sure.
Marinez, that is really small. I don't know if you can make it any bigger, because my small eyes can't see that for sure, or my bad eyes. Okay, sorry, Alan, can you take us through for both condos and HOAs, please?
Sure. So let me just start by taking one very quick step back to what Michael was talking about with this split class. I want everyone to understand you're going to have to take one and then the other. You can't split it between two service providers and think that you're going to get the credit. You know, you need to make sure that if you're going to take it that way, presuming that we end up being authorized to teach it that way, you're going to need to show up for both classes for the whole time, not just one of them, and then take the other one either at a later date or with a different provider. The other thing that I want to point out is that the state has been much more specific since these changes came down the pike with actually asking us to verify that people were on the entire time. So what you were talking about, Craig, 100%, you know, the state is actually policing this significantly more now that it is a requirement. So just wanted to point those things out. Moving on to the official records that you mentioned, you know, we start out with what is the law. We have this list here. I think it's extremely helpful. You know, the governing documents are going to be item number 1. My suggestion is now that you've got to have, at least by October 1st, all of your records presumably were already provided if you're in an HOA to all of your members, not all your records, I'm sorry, all your governing documents, your rules, your regulations, architectural criteria. Hopefully you're going ahead and putting at least the ones that are already in the public record, your articles, your bylaws, your declaration, anything else that's recorded in the county records. Hopefully you're just putting that on the front page of your website and making it accessible to anyone, because it's already accessible to anyone. You're just making it easier to get to without having to search for the name of the association in the county records. You also are going to have certain other records that are listed here that are part of the official records. Now, this is for HOAs or condos. They're pretty much the same records that qualify as official records of the association, regardless of what type of community you're in. The important thing to note is, I'm not sure if it's in this breakdown, but if you scroll down to the end, the last...
Alan, let me interrupt you. Let me interrupt you for 1 second. Sorry, Marinez, we've got the wrong list up. I think you've got the website requirements, not the official records list. Can you just make sure? Yeah, this is the official records. It's way easier to read than the other one. So that's perfect. And by the way, for the listeners, these are available on our website, castlegroup.com, under resources. So you can pull them up later, but sorry to interrupt you, Alan.
No, it's a good point to make. And frankly, most of this comes directly from the statutes. There's a list directly in Florida law that says, here's what your official records include. And we can go through the list, but frankly, I think it's better to just clarify. If you scroll to the last one, and you're welcome to do so a little bit slowly because I talk a lot, so that's fine. But the last one that we're going to see on the list is really a catch-all. And if you look at row number 21 here, thank you. It's all other written records of the association, not specifically included in this subsection, which is the subsection of Florida law we're talking about, which are related to the operation of the association. And when I teach a board certification class, I'll clarify it the same way today. You're really looking at every written record that pertains to the operation, maintenance, or association business in general. Now, what written means could be interpreted different ways. I would rather be more inclusive and make sure that you've got the records you might need if someone files a lawsuit. Some people look at it as, I'd rather not have those records in case someone files a lawsuit. But the bottom line is, anything that pertains to the operation or the maintenance or the dealings of your condo or your HOA, those are the official records. So yes, we've got a huge list here, but going through it item by item, I don't even think is necessary, because this catch-all means it's everything. Now, there are things that are excluded from this list, or at least they are records of the association, but they're not going to be produced to anyone but the board, the manager, and the association attorney. There's a whole list. I don't know if we have that separately, but it's essentially private information of individuals, attorney-client privilege materials that you don't want to leak out while there's potential or ongoing litigation. You're also going to be looking at anything that can be manipulated. In other words, the data of the association. You're going to provide, instead of giving out the QuickBooks login so that someone can access those records, they're going to be accessing a PDF printout that becomes the records of the association. A couple really important things to note, and since we're talking about current law and not necessarily changes, you don't necessarily need to cherry pick records just because someone includes a list of items in their request. They should be kept in an organized manner, which is a change in the law recently, which is frankly a little bit obnoxious, but it's something that hopefully you've got a great management firm like Castle that's maintaining those records that can assist you with organizing them in a way that makes them searchable for all intents and purposes, which is really what the statute is now requiring. But bottom line, what we're looking at is, if it shouldn't get out, it shouldn't get out. The statute's going to clarify what you do and don't need to produce in response to a records inspection request. And those requests are basically anything that's made in writing that says, I want to inspect the records of the association. A couple things to be clear on when it comes to those inspection requests. They don't need to state a purpose. You don't need to say, I want to look at my personal accounting that the association has so that I can figure out whether I'm being charged for things that aren't my responsibility. It's literally, it's as simple as saying, I want to inspect the records of the association. Now, in a condo, this can be sent pretty much any way. I do recommend that the association put together, if you don't already have one, a records inspection policy, because you can limit the way that these requests come in and what they entail and how frequently, how long you have to give the actual inspection for and things of that nature. But you know, whether you have that or not, it can be helpful to basically clarify there doesn't need to be a purpose for this. It's just, I want to inspect the records and you have to provide the inspection, except for the items that I mentioned earlier that are really not subject to inspection because they should be kept private and they are association business and not member business. So there is a list. You know, you're welcome to take a quick look at the statutes, whether you're in a condo or an HOA. If you are not sure whether something should be produced in response to a records inspection, you're going to want to run that by association counsel, because they're the ones that are responsible for interpreting the statutes that govern these issues. But beyond that, I mean, that's the general law. Now, the other thing to keep in mind is there are penalties if you don't produce these records within 10 business days after the request. So in a condo, there's no requirement that it be sent in a certain way, which I was saying earlier, unless you have a policy that dictates how it should be sent. In an HOA, it should be sent via certified mail return receipt requested. If it's not sent that way, you still have an obligation to respond. So a lot of people will tell you, and they'll be wrong, that the statute says that you only have to respond to a request that's made in a certain way. You have to respond to any records inspection request. The difference is that if it's sent in the way that the statute requires, there's a presumption that arises because it was sent that way, that if you don't respond and produce those records for inspection within the 10 business days, you've now intentionally failed to produce the records. And that's what pops up with an attorney's fee entitlement. It's what creates the right to what I call the $50 a day gift that I don't like my communities giving to the members that have requested these records. And that $50 a day gift is essentially, if you don't respond to that and produce the records for inspection within 10 business days after receiving that request, and it's requested in the statutorily appropriate manner, then all of a sudden that owner has an entitlement to $50 per day starting on business day 11 up through business day 20, meaning you can give them a $500 gift plus their attorney's fees and costs for failing to respond to this. So I know Castle, I've never seen you guys, you'll excuse the phrase, but screw this up. But there are plenty of self-managed communities and other management firms that I have seen having problems with this timeline. So it's really important, if the directors get this, to send it on to your manager right away if you're not the one that's directly responding, because the reality is any document you get for the association should be sent to the person responsible for dealing with it. If you don't do that, then you're pretty much guaranteeing that this $500 gift comes to this member if they ask for it. There's a bunch of other things that go into official record. Craig, did you have a question?
Yeah. I just said I really wanted to emphasize your point, 2 points. One, you can adopt an association, notwithstanding the law, the association can adopt reasonable rules with respect to record inspections, and that is hugely important. And they can be published, and we highly recommend that as a best practice. And because these things can get sideways quickly on you as an association, that's number one. And number two, we always recommend any record inspection request goes through at least is looked at by the attorney to make sure that you don't include something you don't want included inadvertently and that you're appropriately complying. Alan, there is a question, and I think, I don't know if you're going to get to this, but about if the records that are requested are on the website, you can just now point some to the website. Is that correct?
Yeah, I mean, there used to actually be condo, I won't call them cases because they were arbitration decisions, but that specifically said you can't do that. And now the law has changed, the statute has changed for HOAs at least. Michael, let me know if you think that it's condo, because I don't recall that this change was made for condos that you could just say, look at the website now. But definitely HOAs have had that change where Craig, you are correct. your response, and if you're hosting all of your official records on the website, and we'll get to websites in a minute, but if you're hosting all your official records there instead of only the ones that are listed as needing to be on the website, your appropriate response to every single records inspection request is, if you don't have login credentials, reach out to me. But other than that, everything's on the website, have at it. And then, if it's on the requestor to come back to management or the association and say, I don't have the login credentials, or I don't have a computer, I can't access them that way. And then the association will decide whether or not to provide some alternative method for the inspection.
Right. Michael, do you know for condos if that's allowed?
Refresh me.
The issue is whether or not we get a records request and the items requested are part of the association's website. Can the association just direct the owner to the website to fulfill the request?
That's the change. That was the change in the Condo Act.
Okay, good. So it's both condos and HOAs then.
HOA doesn't have that yet.
Oh, so I mixed them up. See, this is why I asked.
Yeah. The Condo Act, that's fine. There's a lot going on, guys. And again, we remind everybody.
No.
Informational purposes only. We've got a lot that we're trying to share, pass on. We're human. On occasion, we might not actually say it exactly correctly, but we ask you always to trust but verify, if you will. Yep. But in this instance, yes, it's the Condo Act where the change was, where they added the good part, which is if you have put all of your official records that are required to be posted on your website, obviously not the confidential ones Alan mentioned, then when the individual makes that request, you can let them know, you can direct them to the website and make sure if they need access to it that they can get that access, and that would put you in compliance. There is still a checklist requirement that we believe that you still need to meet, which is the bad part, which hopefully in 2025 we can have them remove. But in the HOA Act, they did not yet say if it's on the website that puts you in compliance. Hopefully they will do that in 2025.
Fantastic. Good. Well, I think the key here, guys, is there has been changes with respect to this records request. So for the first several you get, run them through your attorney. You should always run through your attorney, but make sure that you have the checklist, the appropriate checklist is identified and all of those types, because there's some real nuances in the checklist too. So we're not going to get into that, saving to say that you have to have one and have your attorney review them. Alan, anything else on official records that we didn't talk about that we think we should? Or can we move on, do you think?
The other thing that we didn't mention is there are new requirement to have a records retention policy. And so that's basically how and when are we going to get rid of the official records. Again, you're going to have to retain those for in an HOA 7 years and a condo indefinitely, unless stated otherwise in the governing documents, or there are specific Florida statutes, for example, for election materials. You only keep those for a year, but unless the statute or your governing documents say otherwise, you're generally going to keep those records for the time frame stated in the statutes. And so what everyone was supposed to have done by July 1st, and they told us this in the end of June, but of course, many communities still don't have these in place, but you're supposed to have a policy written that states how you're going to get rid of your documents. My recommendation is have one joint policy that addresses a bunch of different issues. I mean, these are two of multiple, I think 7 or 8 that I think every community in Florida should have, including collection, covenant enforcement, all your other typical things that the association deals with that you can really automate and make the board's job easier by spending a little bit of money up front and having these policies drafted, having the board adopt them, and having also not only the board save time and not having to deal with these issues, but it lets management facilitate moving these things forward the way that they should move.
Excellent. Mike, Alan, 2 quick questions I see submitted in. If the association is missing official records, I mean, you can't produce what isn't there, but is there any guidance specifically if a record is missing? Just say it's missing?
So you do now have
the requester did say HOA, and there is a difference.
HOA, yeah.
Go ahead, Alan. Sorry.
Well, that's one of the things I was going to point out, and I think it was in condo as well that there was a creation of an obligation to look for it. But if you don't have a record, you can't produce it, period. So your response is it doesn't exist. You're not obligated to create records in response to a records inspection request, but you might have an obligation to do a good faith search for it if you have the means to possibly find it.
And well,
Okay,
in the
good.
and I agree with that.
Michael?
With the HOA, I think in the change, I think, Alan, you were touching upon in 718, the obligation to maintain was essentially expanded, where you have an obligation to locate, if there are records that you know are missing, you need to make a good faith effort to locate them and potentially recreate them if possible, in order to avoid being cited by the division for violation of failure to maintain. So that isn't, they didn't put that into the HOA Act, but they yet. But that was one of the changes to the Condo Act that was added in House Bill 1021. They expanded the definition of the requirement to maintain is to make a best effort to find missing or lost records, and that to me includes recreate them.
I think, guys, we're getting into some real nuances. I think when you get these requests and if you're missing records, that's when, you have to reach out to your attorney and get some real guidance for sure.
Right. And I was going to say, because there's some really great questions I've seen on here asking about what happens if records are lost? Can you show owners certain records? These specific questions, please do reach out to your association counsel and get guidance, get proper legal advice.
Yeah, exactly. Okay, let's move on to some deadlines for condominiums specifically. Now, Michael, I'm going to turn back to you. The big one, I think, with respect to condos is websites. So can you review the law? And there were some changes to it. So can you go through those for us?
Well, yeah, the condo one for websites is real quick. I'll just knock that out, and then we'll give the mic back to Alan to go over HOAs, because there's a little bit more for that. And then we can circle back to some older deadlines for condos with me. But these right now, if you are a condo since January 1, 2019, if you're a condominium that has 150 or more units, you should be maintaining an official website. That's existing law. We've gone over the records that should be on the website, what shouldn't be on the website, how you need to provide owners with private access. So even if you have a public website page, and some do, where they'll let people post listings for sale or things of that nature, you need a portal, some user ID password protected area that's just for owners. Okay, 150 or more units. Effective January 1, 2026, and I'm emphasizing that because HOA is 2025. Effective January 1, 2026, if you are a condominium of 25 or more units, the website requirement is mandated for you. So if you are between 25 and 149 units, you have between now and January 1, 2026 to get your website up and going, and to make sure you have everything up on the website that is required to be on the website. If you're 150 or more units, hopefully you're already well established.
Fantastic. And Marinez, there are, for those listeners, we do have a checklist on our website of what is required to be uploaded for condos and HOAs. They are different. So make sure when you're looking at resources, if you're kind of looking for some guidance on what should be included, if you're a condo, pick the condo one. If you're an HOA, pick the HOA one. And Marinez, I'm going to have you show the HOA one as Alan, if you could take us through the HOA requirements with respect to websites, and then the other list of items that HOAs have to have in place at this point or through the balance of the year.
Sure, Craig. So the other thing I wanted to point out, we're talking about the HOA websites, but back to both websites, I'm curious, is Castle providing those for its clients? Because I know some management firms do, some don't. Some have a portal already, but just have to add a front page to comply with the new requirements. Some are automatically doing this, and some are demanding that their clients actually request it and possibly pay a little bit more because the management firm is providing additional services that weren't originally contemplated. So what's Castle doing?
We have as part of our offering, we have a website, and part of our responsibilities as your management agent is make sure the records are on it. So that's a standard part of our platform for self-managed associations. There are products out there that you can get your hands on that will comply for you. But for all of Castle's clients, we have that product available, and it complies to make sure it complies.
It's what I anticipated. Perfect. Okay, so HOAs, Michael mentioned for condos, it's going to be 25 units or more in 2026. This is a fast approaching deadline as compared to the condo one. We're talking about HOAs that never had to have a website. No one in an HOA had to have a website before this year. And technically you still don't, because you have until January 1st of 2025 to get that in place. So if you're working with Castle or most other management firms that I've worked with, they're probably providing that service to you, but you want to reach out and make sure that that's something they're doing and that you don't have the responsibility as a board of directors to make that happen separately through some third-party vendor like Craig mentioned. So again, that's going to be if you have 100 or more parcels, meaning 100 or more lots in your community, you have until the end of this year essentially to get that done. And just like we've talked about in the past with structural integrity reserve studies and milestone inspection reports, there are not 8 million vendors out there that are capable of doing this work. So if you want to get it done, it does take time to build out that website. The time to reach out is now when you've got just about 2 months left before this requirement kicks in. So when we're talking about what goes on the website, separate and apart, one thing you can put on the website to save the association a ton of money is all of the all the copies that we mentioned earlier that were due October 1st, all of your governing documents, your declaration, articles, bylaws, rules and regulations, your policies, architectural criteria, just post that all on the website. And instead of having to send a copy physically, and I've seen document books that I put together for all of our new Orlando area clients, some of those are up to 200-300 pages. Instead of having to mail that out to every one of your members, if it's hosted on the website, you can send a little postcard that says the records can be accessed via the portal. So that's the way that I would recommend doing it, is put all these documents on the website, make them accessible to the members. And if you haven't already sent this out, it was due 3 weeks ago, you might want to do it now. So the other thing that needs to be on this website is information regarding how to contact the manager. The individual manager's basically office hours need to be included on this front page of the website. So that's going to include the manager's name, not just Castle Group, for example. It's going to be the individual manager. Shout out to Dave Beatty, one of my best friends. And it's going to include their contact information. So the address where they can be reached, their phone number, their email address, and if their office hours, so when they're physically in the office, is going to change, they're going to have to change that on the website as well. So they're going to have to be accessible is really what the legislature is trying to tell us. You have to have a manager who's accessible. Again, I don't really see that being an issue with Castle because most of the managers are on site, but it happens more frequently with portfolio managers who have 20 different communities sometimes and are not necessarily immediately reachable. A summary of that individual's responsibilities also needs to go on the website. And then separately from this, you also need to adopt rules and regulations governing hurricane protection. So this is really architectural criteria more than an actual policy, but the statute labels it as kind of a policy that the board needs to adopt. So we mentioned a couple things that you need to do. Like Craig said earlier, if you're looking at your checklist, if you're in an HOA, and again, this is not condo, it's HOA, but you need to adopt your records retention policy. You need to have already sent out the notice where you can get your governing documents at, and you need to adopt hurricane protection standards. These are really rules for each structure that is within the property governed by the association. And it's going to be, you can have either, your standard hurricane shutters. What are the colors? What are the materials that need to be used? You can have your hurricane protective glass. What color, what grade are we going to use? You can also say, hey, if you want to just screw in some, some walling, some wood, whatever you want to use, have at it. That can all be decided by the board. There are limitations on what you can say you can't do that go into the statute. So this is something that you're going to want to work with your attorney on, all these policies. Mailing out the governing documents, I think that the manager can probably handle as long as you run by your attorney what's included in those documents, because some communities are not aware that things were recorded before the current manager came into place. And then once you adopt those policies, the hurricane standards in particular, that's going to go out to all the members by mail, and it's also going to be posted on the association website. Again, like Craig's mentioned, like Michael mentioned, like I mentioned, from my perspective, there's no reason if you are required to produce these documents, these records to your members, there's absolutely no reason not to put them on your website so that you don't have to keep sending them out every time someone asks for them. Your response to every request is they're on the website's organized. If you can't find it, let me know.
Right. And
Yeah.
again,
Good.
to piggyback off of that one, Craig, again, because of the change in the Condo Act, you definitely can say to an individual, as long as you properly put all the records on the on the website,
Right.
you can definitely respond to a written request within 10 business days that, we've received your request, that the records, all the records you've requested are available to you at the website. If you need a user ID password, please contact us. And then, should we not hear from you, we'll presume you were able to get access, all good. Something like that. And work with your counsel to get a form or something to that effect. HOA, you can do this a similar, but you can't, in my opinion, based on the way the statute is, you can't just dismiss it. You can say, hey, the records can be made available to you. You can come to the office these days, these times. However, they are available also on the website, user ID, password. So if you prefer, you can go ahead and do that. Then, if you don't hear back from them, I think you have the documentation to support the fact that we gave them dates and times. They didn't respond because they reasonably presumed they hit the website. That's just, there's a minor distinction because the statute doesn't yet mandate HOA the way it does condo that way.
Excellent. Well, I think, guys, that's great guidance. There is a question whether Building Link has the website. They have the functionality in Building Link. A lot of our condos use it. I think it's important. The fact that you have the functionality doesn't mean all the records that are required to be there are there. So take advantage of the functionality, but make sure you go through the checklist and, and update the records. So,
yeah.
Alan, that's a great summary. Lots of stuff, some past due deadlines we've talked about. Let's pivot now, Michael, back to you and some old news, I guess. The whole milestone inspection and SIRS initially established in 22, but we're quickly approaching some deadlines.
Yeah.
On that those laws. So can you give us a summary? And Marinez, okay to take down the checklist.
All right, real quick, I do want to answer one question about the board certification classes that was asked. No, KBR does not charge any attendee to attend any of our online classes. I'm aware that there may be some firms who do that if you're not a client of the firm, or they might charge everyone. KBR does not do that. We enjoy and we like to give education out. Obviously, we make ourselves available if you require legal services at some point, but it is not mandated in order to attend our education classes. So feel welcome to join them.
Okay.
Now, with regard to what, Craig, you asked me to follow up, guys, it is 12:50, and we have a few more items to touch upon. So I want to be very clear. This is very, very surface in nature. This is really just sort of like a one-liner reminder to those of you who very few of you, if any, I'm sure this is going to be a surprise. But I would just want and I respect the fact that Craig and Castle wanted us to kind of prod you a reminder on October 22nd of 2024 that these are deadlines of December 31st, 2024. So I'm sure you're on them. But please do understand, this is an hour-long conversation. We've had many hour-long conversations about milestone inspections and structural integrity reserve studies. This is going to be a 2 to 3 minute, just one bullet points so that you can make a note and you can follow up with your management team, follow up with your counsel, and make sure you're on top of these, okay? So again, the milestone inspection for all buildings 25 years of age or older is, and I'm focusing especially here in Broward County, but if you're 25 years of age or older in 2024, then inspection should be done by the end of this calendar year. If you've not already done it, you should be under contract to do it. If you're under contract to do it, and the qualified engineer or architect, properly licensed engineer or architect, is unable to get to your building prior to the end of the calendar year, but you are under contract, then that is going to at least show a good faith effort. Should the authority having jurisdiction, which is typically your municipality, comes to you and says, hey, where's your report? All right. I do want to remind everyone in Broward County that you're going to get letters from your municipality. It is not necessarily, unlike the milestone inspection, which is for condominiums 3 stories or higher. Broward County focuses on size, on square footage, not necessarily 3 stories or higher. So you might be less than 3 stories, but have a larger square footage, and you'll get that notice from municipality. So just keep that in mind. Okay. And if you do get it, and it is a 20 in Broward, it's 25 years that they're looking at. The structural integrity reserve study, for those who were condominiums who were 3 stories or higher, cooperatives 3 stories or higher. By December 31st of this year, a little more than 2 months, you're supposed to already have your structural integrity reserve study completed by a qualified individual under the statute. With regard to the structural integrity reserve study, there is a reporting requirement. Well, that was it. There's a reporting requirement for the milestone inspection as well. But the change that happened this year has to do with the structural integrity reserve study. And within 45 days of your receipt of the structural integrity reserve study, it is to be, you need to notify the membership, and you need to notify the division. Okay.
Michael, we have a screenshot. Can you pull the screenshot up? It's very easy to notify. Marinez, can you pull up the screenshot of where you register it with the state? Well, Michael's taking us through that.
Yeah, and so the first part is within 45 days of you receiving your structural integrity reserve study, you should post it on your website if you have a website requirement. And if you don't have a website requirement, but you have a website, put it up there. But then you also need to deliver it to every owner, either mail, if they've consented to email, you can do that. And then you also need to notify the state. And I don't know, Mariners, if you want to make that a little bit bigger. You need to notify the state that you have obtained your structural integrity reserve study and that you have either sent a copy of it to every owner or sent a notice to every owner that the SERS is available and that they want to come and get a copy of it. Okay. I do want to highlight something that I was that I understand is if you go to that link that you guys just put up to let them know you've done your structural integrity reserve study. I don't know if it still says it, but my understanding is there was a requirement that not only were you supposed to notify them by their form that you've got it and that you've notified the membership, but they asked for a copy of the study. In my opinion, there's nothing in the law that requires that you provide that, and you should not upload your SERS to that site. Okay, that SERS is something for the membership to see. It's financial information documentation for the membership. That's who should have access to it. It does not need to be posted on the website. The requirement by statute is that you notify them that you've gotten it and that you've properly notified the membership. You do not need to give them a copy of your SERS. And for that is informational, confer with your own association counsel to get legal advice.
Yeah, Michael, I will say, guys, for those who can't read it and it's hard, it's just the DPBR website, and you just have to scroll through. It's an easy walkthrough to SERS reporting. So www.myfloridalicense.com or DPBR, search DPBR, and you can find it. If you have trouble, let us know and we'll send it out to you. We'll also post it on our website. Sorry, Michael.
No, all good. That was it. I mean, that was just,
okay.
Again, I told you it was a very, very brief summary of those, because the deadline is the end of this calendar year for both of those. Assuming your building is 25 years old. Now, if your building was built less than 25 years ago, then your milestone inspection is not due yet, but your structural integrity reserve study still is.
Yeah, good stuff. I appreciate that. And I think just to remind everybody, I think it's important. The key here was you should have had it done, or you have to have it done by December. If you get it, there are reporting requirements. If you're not ready, make sure you're contracted to do it. So at least you're showing some process in case DPBR goes back.
Yes, good faith.
Good faith efforts. Yeah. Okay, let's go on, Alan, to the Corporate Transparency Act. Another piece of legislation that's going to require the association to do something. The website is fincen.gov, but can you take us through, Alan, the requirements to the Corporate Transparency Act?
Sure. So, I mean, the major requirement is that you file a beneficial ownership information report with FinCEN at the website that you just mentioned by the end of this year. We're getting a lot of people asking, are we doing this for clients? The answer is, frankly, we don't need that kind of responsibility. The reason that I say we don't need that responsibility is because you also have an obligation, if you're the filer, to update that information within 14 days if any of the beneficial ownership information changes. People are asking also, what is beneficial ownership? Because the members don't necessarily own the association unless you're in a co-op that you might have shares. But in a condo, in an HOA context, it's really who has control over the operation of the association that the federal government is looking at. So what we're really looking at is who's on the board. Those are the people whose information is going to be uploaded. You know, I
Directors and officers, yeah, who oversee. Let me just jump in real quick to clarify one other thing too about you need to update, you need to provide the personal identifying information. Might be a passport, might be a driver's license. And to Alan's point is there's no need, at least as far as we're concerned, that this law firm has that information on in our records. We don't need that personal identifying information. For those of you who are already signing checks, for example, your management companies have that information because on file, because they are, you know, in order to get your checking accounts and things open. Am I right on that, Craig?
You are, in fact, guys, Castle has a program to make sure you comply and assist you through that process. You would have just got an email blast from us if you're a board member on how that whole process is going to work. So we are taking that responsibility on
Right,
for
but I'm
our
saying,
associations.
but don't you have
But
that
yes.
identify, like if people are like your board members who have to have check signing authority through the banks, you're going to collect that information anyway. And again,
We
to
have
Alan's
it.
point also, logically, your management company is going to know if a board member resigns tomorrow, they're going to know right away and be able,
Yeah.
because you have a 30-day window to update it. The law
Yeah.
firm may not. You know, it's not like the kind of thing if we're a registered agent that we're going to get that type of notification. So logically,
No.
in our opinion, it doesn't make sense for the law firm to be the responsible party when you have a quality management, you know, or a third-party provider.
Completely agree.
That as their job.
You can do this yourself, but as Castle client, we're going to take this on, and we've sent you an e-blast on how that whole process will work. Alan, anything else on the beneficial ownership and the CTA?
With 1 minute, all I'll say is that I don't think it makes any sense to require a community association to do this when it's intended for counterterrorism purposes, but I don't control that.
Well,
yeah, and guys, I think audience, we are going to go a little over. We're going to go a little over here, so I think you know, stay on. If we have a couple more things I want Michael to talk about specifically as to what's coming down the pike, but on the Corporate Transparency Act, there has been some publicity around a lawsuit filed by CAI to try and exempt associations. The fact of the matter is the deadline's 12/31, so we're all in unless we hear otherwise, because we don't want to not comply, and there are penalties for non-compliance.
Correct.
So
if I can add 2 quick points, if I can.
Please.
On that. Okay, and by the way, thank you for for us going over. You know, look at you, flexibility.
Mr. Flexible, that's me. That's what they call me here at Castle.
Yeah, look at that's coming with the age, I think. So 2 things. Yeah, as you pointed out, Community Associations Institute Nationals organization has already filed a lawsuit against the U.S. Department of Treasury, and they have already had a hearing on their request for a temporary injunction, and that is expected to get with the hearing, the ruling is the word I'm looking for, to be within days or certainly weeks, and obviously because the deadline of December 31st, so they're pushing to get a ruling on that temporary injunction. If that injunction is granted, it will delay the deadline for community associations. It won't eliminate it, but it'll delay it. There is a bill in DC in the House to exempt community associations, but we all know how long that can take. But there are efforts being made. If you have an annual meeting between now and the end of the year, it does not make sense for you to put your information in now. Wait until your results of your annual meeting before you file with FinCEN, because you need to have the most current. Now, if you know, if you're a condominium, and you know, hey, we understand our elections in 30 days, but there's only the same candidate, same directors are the only candidates, so there is no election, they're going to be seated. Okay, then you already know. But if you don't know that, I would suggest you wait and see what that information is. You also might want to wait to see if they do get this temporary injunction. And I just want to highlight one last point on that, Craig, because I just want to point out what CAI has put in their blast, and we have sent it out. If you are a member of CAI, a member association of CAI, and they get this injunction, then they're saying it will definitely, your association will definitely qualify for that injunctive relief. What is unclear per CAI's, no, this isn't me, this is per CAI's blast, is if you're not a member association of CAI, will that temporary injunction apply to you? And that is based on this one other case that happened out in Alabama earlier this year, where a business organization did get an exemption from the Corporate Transparency Act, but it only applied to members of that business organization. So CAI is saying, CAI is suggesting that you consider becoming an association member of CAI, so to protect yourselves should that be the interpretation on the ruling. I don't get anything out of it, guys. I'm just offering. We have put it out in an email, and you can go to CAI's. If any of it's throughout the state. You have chapters throughout the state. It's like $300 to become a member association, and that applies for up to 15 directors. So in my opinion, it's worth it because they have a lot of resources anyway. But it would also potentially protect you if that is the interpretation. So I just wanted to put that on there. I think that's important to share.
I think it is, Michael, and I wanted to wind up with you. You know, there's been lots of noise about a potential special session, maybe with you're back on the CAI Legislative Committee. So just any ideas as we wind up here about what may be on the legislative agenda in Tallahassee in 25?
Yes, absolutely. And it's going to be a very brief statement. So I will take the first minute because you had wanted, you highlighted this and I don't want to forget it because of the overall premise of our presentation is upcoming deadlines. ELSS is still there, guys.
Oh, sorry, yeah.
And so, again, you're going to definitely want to communicate with your management team, with your council. They did extend, there's a 3-year tier, if you will, but by January 1st of 2025, whether you're doing fire sprinklers or ELSS, my understanding is you're supposed to have developed the engineered design criteria and submitted that criteria to your authority having jurisdiction for review and approval. And then you'd have another year to apply and get the permit. And then another year, meaning by January 1st, 2027 is when you'd actually have to have the system installed if they don't push those further. But right now,
thank you.
But you're still supposedly by January 1 of 2025 to have communicated with your authority having jurisdiction and provided them your design criteria.
Yep.
Those of you who've been involved in that for a long time, so just keep that in mind and touch base with your management team and your council to get more specifics on that. Okay. Yes, you're welcome. All right. Regarding legislation 2025, what's possibly upcoming? Craig is, we've mentioned Community Association Institute, Florida Legislative Alliance, which is an action committee that I have had the pleasure of voluntarily serving on for 15 years about. And I'm very proud to be back as a delegate there, working with 20 plus other volunteers throughout the state in community association industries, where there's a few lawyers, but we also have managers and homeowner leaders and bankers and insurance agents, CPAs. I mean, it really is a cross-reference of the industry and the state. We work with our great lobbyist, Travis Moore, and we are going to be up there fighting the good fight for you guys. We're going up in January. Session starts in March. Right now, not surprising, all focus in Tallahassee is on November elections in less than 2 weeks. Or actually, 2 weeks from today. Right? 2 weeks from today is election day. So that's where the focus is. Whether there's going to be, first I was told there's definitely not going to be a special session. After that, like early December, then I was told there's going to be. The governor was pushing for a special session to try to address the expenses involved, especially in the condominium world. I thought that was, a little bit late to be doing that, the governor, but good on you. In this election year to push that forward last minute. But the whether there is going to be a special session or not is still unclear to me. If there is going to be one, it's going to be in early December. And I don't know, and some of the talking points, as I understand, is really determining whether they're going to do like a glide path is the word I believe they use. And let me make sure I have that word right. Yeah. Glide path. And by glide path, that means, are they going to allow the condominiums who are subject to the structural integrity reserve study and funding requirements to have a tiered buildup? I think something that we talked about in 2022 when they were first pushing this, like maybe don't make it all maybe do it over. So there is discussion on that. At least there's discussion coming from the Florida Legislative Action Committee. And there is, but there is some, willingness to listen certainly by some of those, especially local senators and representatives here, Whether it's going to change anything is an unknown. And so what I need to emphasize is the law is what the law is today. And the law today is requiring that you make sure that you have your milestone and your SIRS studies by the end of this year. And those aren't being pushed back. You need to have those at least done. And that you are required to address the full funding of your SIRS reserves in your 2025 budget, unless you are going to go out to the membership before the end of this calendar year and get a majority of all members to approve less than fully funding those structural integrity reserves for your 2025 budget. It's a conversation to be had that's more than just 10 seconds. So follow up with your counsel. I'm working with a lot of our clients now, as is Alan, on membership voting and budgets, because this is the season now. We're middle end of October. So get with your counsel and make sure you're doing that correctly if that is what you want to do.
Good stuff. Okay, well, guys, let's wind it up. Thank you so much, Michael and Alan, for your guidance. As always, appreciate it. And to our listeners, I will remind you you can replay this webinar on both, I think, KBR's website and Castle's website, castlegroup.com. There are some resource materials available in terms of official records and what should be on your websites, whether you're a condo and HOA. So visit and grab that information. We really appreciate you all taking the time to listen in. Guys, have a great afternoon, and we will catch up soon. Thank you, everybody.
Thank you.